and welcome Sorry, I started a second early there. Hi, and welcome everybody. We're going to give it about one more minute for a few more to log on, and then we'll get started with tonight's presentation. Good evening. We're going to get started. My name is Michelle Lyday. I am a member of the Law and Related Education Committee here at the State Bar, and we are really excited to welcome you to the first in our series of Citizen Law School presentations. Tonight, we have Danna Jackson that's going to talk to us about basically tribal law, a little bit of a primer on that big subject. Uh, if you'll help me welcome her, Danna Jackson is a tribal attorney for the Confederate Salish and Kootenai tribes. She has also worked in the federal government as a federal prosecutor, tribal liaison, a senior counselor at the Department of Interior, a Hill staffer, and an attorney for the National Indian Gaming Commission. In the state government, she has worked as chief legal counsel to the Department of Natural Resources and Conservation, and she's also been in private practice. So she has a wealth of experience that she's bringing this evening. Her work has centered around Indian, natural resource, and water law. Also, Danna has enjoyed teaching at the University of Montana Law School's Indian Summer Law Program. They typically have that each year. And after bouncing back and forth between Montana and Washington, D.C., Danna is now happy to live in Polson, Montana with her husband. They are now facing that empty nest phase of their lives, and we are so excited to have her here with us. A couple of ground rules before I turn it over to Danna. We welcome you to ask questions. You can place those in the Q&A, and we will get to those periodically throughout the presentation. I'll be monitoring them. And Danna's indicated that this PowerPoint will be available. I believe the State Bar will put that up and make that available if you're interested in reviewing it. So again, join me in welcoming Danna. Thank you so much.
Thank you. I like to start my presentations by saying, why am I qualified to talk about this? We're going to talk about, oop, oop, it's not what I wanted to do. Sorry, I'm going to try to move my slides. Oh, here we go. I'm putting it in slideshow. Sorry about that from the beginning. Okay, why am I qualified to talk about this? What we're talking about is a refresher on tribal court jurisdiction, both criminal and civil, and we're going to talk a little bit more just generally about Montana tribal courts. And the answer is I've practiced in a lot of Montana tribal courts, and also when I was tribal liaison, when I was a federal prosecutor, there was a whole lot of effort put into tribal court trainings and law enforcement trainings for purposes of building capacity and relationships between the federal and tribal court systems. And I'll try to refrain from war stories because we don't have enough time, but I thoroughly enjoyed a career where I was able to practice in tribal court. We're going to start with criminal. Once upon a time, there were two men in a simmering feud, Crow Dog and Spotted Tail, and they lived what is now the Rosebud Indian Reservation. And Crow Dog killed Spotted Tail, and it was over tribal leadership. And Crow Dog was tried in accordance with tribal customs and tradition. And at the end of the day, when they all got together to figure out, man, we've been wronged, Crow Dog's people gave Spotted Tail's people restitution, to use a legal term, in the form of $600, 8 horses, and a blanket. This was around 1880. And everyone was happy. Well, probably not super happy, but it was, justice was handed down and everyone was okay with that. But the feds who were newly minted, probably U.S. Marshals for the territory of Dakota, didn't think it was a good outcome. And so they detained Crow Dog and they put him on trial in federal court. And Crow Dog was guilty, found guilty of murder, and he was going to be hanged. And while in prison, he filed a writ of habeas corpus with the Supreme Court, and it was granted. And so then the Supreme Court took a look at the Treaty of Fort Laramie, and it had this provision in it that is very dramatic. And it says, if bad men among the Indians shall commit a wrong, the Indians agree that they will deliver up the wrongdoer to the United States. But the provision was drafted to apply to non-Indians on the reservation. And because this was purely an Indian on Indian crime on the reservation, the court concluded that the treaty left exclusive jurisdiction to the tribe. The federal government had no jurisdiction over Crow Dog. He was released. And that's the end of the story, right? No, of course, it's not the end of the story. Congress didn't like that decision, and so it reacted, and as a result, passed what we today continue to call the Major Crimes Act of 1885. And the Major Crimes Act grants the federal government criminal jurisdiction over an enumerated list of crimes committed by an Indian against an Indian. The original list had 7 major crimes, the big ones: murder, maiming, serious bodily injury, all the sex assaults, etc. And Congress also provides, then later, a few years later, Congress also said, you know what? We'll also give the feds jurisdiction if the Indian person is either a victim or perpetrator of a crime. It was 7 major crimes. Today, after, many different amendments, I think it's up to maybe like 17 different major crimes, which the feds have jurisdiction over Indians in Indian country. So when I was in a jury trial in, in federal court, it was very interesting because a lot of folks would show up and they'd be like, this is federal court. What are we doing with a serious bodily injury case involving Indian country? This is why. And so this kind of kicked off the framework for um, jurisdiction, um, jurisdictional issues in the criminal context. Um, and then there's 2 themes that will start developing here. Because of the nature of federal Indian relationships, the tribes have been subject to diminishment of their authority, either through case law development or through congressional acts. And so that Crow Dog case, and then what happened as a result of it, is an example of how the tribal court or the tribal decision makers authority was taken away from them. And another example was in 1968, the tribes were subjected to the Indian Civil Rights Act. And you would think, oh, that's a good thing. And for those of you who were around in the 60s, you know that, or those of you who follow history, this was like the time of the Voting Rights Act and Civil Rights Act and all kinds of progressive acts relative to preserving civil rights, etc. In the context of Indian country, they decided, you know what, we want to impose most provisions of the civil liberties protections in the U.S. Bill of Rights on tribal government and tribal courts, but we're still like not completely comfortable with tribes asserting too much criminal jurisdiction authority. So they limited their ability to sentence a criminal up to 1 year and levy a 5,000 fine. And you could stack 3 different charges, though. But nonetheless, what this did is it developed the system that we're pretty familiar with today, where most tribal courts are courts of misdemeanor jurisdiction when it relates to criminal matters. So I said earlier that it imposes most of the civil liberties protections of the U.S. Bill of Rights, and I just find this interesting that these were some examples of very specific ones that were not um, um, imposed by the Indian Civil Rights Act, and was there's no separation of church and state in the Indian Civil Rights Act, no right to counsel in a criminal case, and there's been some nuance related to that, especially lately, relative to uncounseled decisions. And there's no right to bear arms in the Indian Civil Rights Act. So Congress put parameters on and limitations on what the tribes could impose relative to criminal matters. So not only does Congress impose limitations, but also the case law continued to develop so that you could see that there was a trend towards continued diminishment of um, tribal assertion of, in this context, criminal jurisdiction. This is a very famous case. It's Oliphant v. Suquamish Indian Tribe. We're going to talk about it a little bit. It was 1978. Mark Oliphant was a non-Indian who was convicted of a DUI and disorderly conduct by the tribal court. He was driving drunk on the Suquamish reservation. He filed a writ of habeas corpus claiming the tribe had no authority over him because he was not Indian. And in this instance, the U.S. Supreme Court looked at the Crow Dog decision, looked at the Bad Men Treaty provision, which, as we described previously, we know that that applied to non-Indians. And so the Supreme Court determined that Indians do not have criminal jurisdiction over non-Indians absent affirmative delegation of such power by Congress. So, again, another limitation of what tribal courts can do relative to criminal jurisdiction. This created an interesting scenario, though, because what if they're a non-member Indian but on an Indian reservation? And as an example of how the Supreme Court doesn't necessarily understand how it is out in the West, the next case we're going to look at is Duro v. Reyna. The court held that the same principles of Oliphant extended to tribal prosecutions of Indians who were citizens of different tribes. So after Duro, tribes only had criminal jurisdiction over their own citizens. And if you think of places like where I'm from, CSKT, we've got Salish Kootenai College, we have all kinds of other non-Indians married to members or residing here for school or work. And so you can imagine kind of what a nightmare scenario that would be if tribal law enforcement or any law enforcement pulls someone over and says, "Oh, okay, are you an Indian? What kind of Indian?" And so it did create a difficulty for, I guess, the administration of justice, given the fact that a lot of Native people live on each other's lands and reservations. And so again, Congress reacted. And in this context, because of the chaos, the Congress amended the Indian Civil Rights Act. Remember, we talked about that a couple slides before, to forever recognize tribal criminal jurisdiction over all Indians. So Congress said, tribal courts, you can have federal criminal jurisdiction with all its limitations over anyone who's a native. Of course, you have to look at the tribal code to make a determination of exactly who the tribe says it has jurisdiction over, but that happened. So it was, I hope I'm painting a picture of the diminishment of tribal court authority and jurisdiction. In 2013 and 2022, it started changing. And I don't know how many of you know about the Violence Against Women's Act, but it gets reauthorized from time to time. And in 2013, and actually earlier than that, there became an Indian title to deal with the very specific issues related to violence against Indian women. And the Violence Against Women's Reauthorization Act of 2013 included a very historic provision that started changing it so the tribal courts had ability to assert more jurisdiction in their tribal courts. And it was called the Limited Oliphant Fix. In other words, it provided tribal courts opportunities to now have jurisdiction over non-Indians in certain instances of domestic violence acts. And so they set it up so that there were some criteria participating tribes had to have to be able to exercise this type of jurisdiction. There were, I think, 6 pilot tribes. You'll be happy to know one of them was a Montana tribe that asserted themselves, and that was the Fort Peck Indian Reservation. They decided they wanted to go ahead and move forward and expand their jurisdiction. Um, I was always a proponent of this, of you know, having tribal courts proceed with expanded jurisdiction and taking on more authority over non-Indians who commit domestic violence against um, Native people. It was controversial, however, because to a certain extent, some folks said, why is it we should be making tribal courts look exactly like federal or state courts? The beauty of tribal courts or tribal court assertion of jurisdiction or dispensing of justice is their ability to make it more oriented toward the community that they're from, and they have a lot more flexibility in sentencing and et cetera. So um, when I was an AUSA with the federal government, I wanted to make sure the tribes knew that they had this ability to expand jurisdiction, but I did get some pushback. Um, Around the same time in 2010, there was this massive Tribal Law and Order Act that was also passed. And basically, the provisions of the Tribal Law and Order Act that allowed tribes to have expanded jurisdiction was the same as VAWA 2013, a little bit different. But one of the things that the Tribal Law and Order Act said is if you want to have expanded sentencing and more authority, we want you to make sure you have effective assistance of counsel for defendants, free appointed licensed attorneys for indigent defendants, law-trained tribal judges who are also licensed to practice law, publicly available tribal criminal laws and rules like online codes, and recorded criminal proceedings. So I would say, a majority of our tribes in Montana have lay judges and lay advocates in their system. And so, not all of them, but in this instance, they were like, okay, we need some attorneys in the mix in the tribal court systems before we're comfortable proceeding with the tribal courts asserting more jurisdiction. A couple provisions that I found particularly interesting is it included a fair cross-section of the community and jury pools that does not systematically deny non-Indians from serving. It's hard enough to get, you know, um, a jury of our peers, but can you imagine getting a summons if you're a non-native person to tribal court to sit on a jury? Now, of course, I'm nerd enough, I would love that. But yeah, that's required. And you have to inform in writing defendants ordered detained by a tribal court of their right to file federal habeas corpus petition. So an extra layer of due process there. So to me, I know that this might sound like an overstatement, but this was really profound. This was a really profound reversal of courts and Congress taking away tribal court jurisdiction. Instead, it was starting to kind of build back. And to that end, VAWA 2022, when it passed, Congress expanded the list of covered crimes, um, and it included assault of a tribal justice personnel, child violence, obstruction of justice, sexual violence, trafficking, and stalking. So it provided specifically that tribes have ability to bring these types of cases in their system. I do need to stop and say tribes could already, because they're inherently sovereign, have murder and all these major crimes are more, I guess, less misdemeanor like crimes. They could already charge those, and they already did, but they just had limitations on their sentencing, which made them want very much so the feds to step up and handle them in a system where they could elevate it to more of a felonious charge. So, we need to talk about CSKT, and I'm sure a lot of you have heard about it in the news. What about CSKT though? But wait, it is the only reservation in Montana that is not subject to federal jurisdiction. The tribes early on um, decided to opt into a scheme that's called PL 280, Public Law 280. It allows the state to assume criminal and civil jurisdiction on the reservation. Montana was not a mandatory PL 280 state, but nonetheless, the powers that be at the time at the tribes thought that it would make more sense because probably of the demographics of our reservation that the state would have jurisdiction over the felonies and not the feds. So that's why we don't have FBI officers running around on our reservation in the same way as other reservations. Of course, this may change too. And so we're just waiting to see what the political will is of folks. And we'll see what happens. This could change so that CSKT might become like the other reservations where the feds are charged with the major crime prosecution. And I've got a couple charts for you that you can look at later. This looks complicated. This is the non-public law 280. And this is the, if it's PL 280. I'm not going to hover on these too much. To me, it was easy in Montana to determine jurisdiction for criminal matters. Did it happen on the reservation? And is there an Indian involved? And if those two things were true and those are elements of the crime, then the feds would have jurisdiction. So it was, it's a lot more simple to assess jurisdiction than in the civil context that we'll get to later. But I think it's important to think about the evolution of tribal courts in the context of history and how this all happened with changing policies relative to the federal government's understanding of how to manage the Indian issues through the years. I have no more to talk about on criminal jurisdiction unless you have questions, and then we'll move on to the civil jurisdiction component.
Anna, there are a couple of questions. I think you might get to this in the civil portion, but one of those questions is, can tribes provide rights in their tribal constitution that are not enumerated in the Indian Civil Rights Act?
Yes, the answer is yes. Um, and you will see that a lot of the Montana tribes have what's called the IRA, Indian Reorganization Act Constitution, that was kind of handed to tribes when they decided, okay, in the 30s, we're going to we tried to terminate reservations. It didn't work. So why don't we make sure that tribes have tools to do self-govern, self-determination to a certain extent? So in the 30s, the most tribes adopted an Indian Reorganization Act constitution. So a lot of it has similar rights to the US, and that's that makes sense to a certain degree, but then you have um, reservations such as Crow that has done a major rehaul of their constitution. What I'm excited to see in the future is, of course, now we have 8 federally recognized Indian tribes in Montana, and the last one was Little Shell. I'll be interested to see how they arrange their constitution in setting up their justice system because they get to start with all the wisdom of all looking back at what has and hasn't worked with other reservation systems to set up a system that hopefully is, a reflection of their community.
And Dana, along that point, since Little Shell doesn't have allotted reservation land, how will that work as far as determining jurisdiction?
I think they own land. I'm not sure it's all in trust yet. I think that they're working on getting their land base established before, and I understand that I understand that they're like working on a health center and other components of governance before they get to this piece of it, the tribal court piece of it. So I think that we need to sit back and watch and see how they end up organizing themselves. It'll be really, I think it's exciting.
That sounds great. And then one last question here. Does the federal government shutdown impact tribes?
Oh, definitely. Today, when I was sitting in my tribal office, we did get an email from our our folks saying there's no immediate impact. We have enough tribal funding that it's going to be fine. We're going to proceed. But a lot of tribes do rely on federal grants. And a lot of tribes aren't as independent or self-governance oriented as CSKT, for example. So they demand direct services. Some of the tribal law enforcement contracts are we compact with the federal government, and so we, the tribes, run our own law enforcement, for example, whereas some other tribes it's BIA law enforcement, and so they're federal employees doing the same function. And on those reservations, I think there's a much larger impact on a federal shutdown. My hope is that they are tribal law enforcement, Indian health services that provide direct services are considered essential services so that they will be able to continue on. But there's a whole lot of other function that does get paused. So it's a mixed bag for sure.
Thank you. That's what we have for now. Thanks.
Okay. All right. Well, we're going to talk about the other side of the coin, which is civil jurisdiction. And when I talk about civil jurisdiction, I talk about um, non-criminal matters, regulatory matters, as well as disputes that you might think about in the context of child custody, divorce proceedings, creditor work, contract, personal injury, probate, those kinds of things. So um, we are going to again look at case law because that's what us lawyers like to do. So in the civil context, there's a very major concept that we need to throw out, which is the concept in the Williams v. Lee case, and this was 1959. This was a non-Indian store owner located on the Navajo reservation, brought a debt collection action against a tribal member in the Arizona State Court. And the Supreme Court held that absent governing acts of Congress, states cannot infringe on the right of reservation Indians to make their own laws and be governed by them. So this is just a very broad concept that you need to have in the back of your mind, which is states generally won't have jurisdiction in these matters, but let's see how the law has developed. Oddly enough, most of the jurisdiction cases that have arisen in the civil context came out of Montana. And in fact, the judicial limit of self-determination we call it the Montana test. And it was 1981. It was a dispute over who could regulate fishing on non-Indian fee land located within the Crow Reservation. The Supreme Court held that absent a treaty or federal statute that controls, tribes did not have jurisdiction over the activities of non-members on alienated fee land within a reservation. But then they gave us two exceptions. And these are really important. And this is what I guess means job security for people like me. These exceptions are what are fought over all the time, and a lot of case law has developed as a result of interpreting these exceptions to the Montana rule. The first one is for a non-member consent to a tribe's jurisdiction. So through contract licensing or other evidence of consent to a tribe's regulatory adjudication jurisdiction. Um, when I'm negotiating a contract with a company that we're going to connect with to make widgets on our reservation, we'll put in there, and you will consent to tribal court jurisdiction should there be a dispute that arises. And if they agree to that, then that's consent. That would be consent. So that's when they're saying, okay, the tribes will have the authority and jurisdiction to deal with this civil matter. A second exception, though, is the one that is more confusing, is when non-member conduct on non-tribal fee lands within a reservation threatens or has some direct effect on political integrity, economic security, or the health or welfare of the tribe. And when I first read this, when I was in law school, I was like, whoa, that's a really broad exception. Because a car wreck on the Indian reservation that involves a native person, how does that not impact the health or welfare of the tribe if individual members are getting killed on a highway? The truth is, there's been a lot of limitations put on that specific section. What does health or welfare of the tribe mean? And the big case happened the year after I graduated from law school. It was Straight v. A1 Contractors. And applying the Montana test, the court held that absent congressional authorization, we see that language a lot, don't we? Tribal courts cannot adjudicate civil matters between non-members that occur on state-maintained public highways passing over reservation lands. So this shut the door to personal injury lawyers bringing cases against non-Indians who might have caused an accident where a tribal member or an Indian person is hurt or injured on the reservation. So I like to point this out. Justice Ginsburg delivered this unanimous decision of the court. A lot of people still continue to glorify the notorious RGB, I guess is what we call her. But as it turns out, she wasn't great on Indian issues. And so this was a major blow to civil jurisdiction and tribes' abilities to be the forum um, to assist with dispute resolution. And this was a major case. Um, I do like to point out that I'll give you an example of a case that I was working on when this case came down, and I was representing. What happened was this student went into a school in Lame Deer and set the bathroom on fire. And the school district had um, modular classrooms at that time. So a modular classroom did light on fire, and it was a pretty catastrophic structural, um, uh, um, I guess, problem. I mean, it burned down and no one was hurt, but the school district ended up suing the manufacturer of those modulars. And I represented the company, the modular company. And it was a case that was in the um, Northern Cheyenne Tribal Court. And so I was perfectly happy defending the case in the tribal court. And the tribal judge, who was an attorney, was managing the case just fine. And we were starting to do depositions. I was starting to learn more about the UBC and all the requirements of safety for schools, et cetera, when this decision came down. And needless to say, we settled the case pretty quickly because once the plaintiffs, who thought that they were going to get a huge payout in the tribal court, knew that that wasn't going to be where they would be trying a case, they became more reasonable relative to a settlement of that matter. So anyway, interesting time in a history of civil jurisdiction. I wanted to give you an example of another case where in this instance, the Ninth Circuit decided that this tribe had jurisdiction under the Montana exception that we were talking about. In this instance, it was a non-Indian company storing large quantities of elemental phosphorus on fee lands within an Indian reservation. EPA determined the chemicals stored on the site could ignite, causing burns and inhalation hazards from aerosols that could drift from a site. And witnesses testified that they saw ducks spontaneously ignite as they took off from the containment ponds. In this instance, because of the demonstration of serious harm, they did determine that this was an appropriate exception to the Montana rule. So ducks lighting on fire is persuasive, I suppose. I think that it's really important to realize that when you're determining tribal civil jurisdiction and or regulatory jurisdiction, you have to decide if the Williams case or Montana controls. And so you really need to do a case by case analysis. Who are the parties? Where did the conduct occur? What is the land status? Who is a plaintiff? Who's the defendant? What's the subject matter being heard? And if Montana controls, is there a treaty or federal law that controls? Is there a first or second exception that controls? So it takes a lot of energy to determine exactly whether it's a tribal court matter or not. And it's really important to know that, again, cases coming out of Montana, the federal law has long recognized a respect for comity and has determined that tribal court is the appropriate court of first impressions to determine jurisdiction. In other words, you can't just go straight to federal court. You have to have the tribal court make a determination of all those factors that I talked about in the previous slide and let them make a decision, first of all, whether they think they have jurisdiction. And they won't always say they do. I had a case where this was a subject matter jurisdiction challenge, but I represented a union, and a teacher was suing the union, saying the union didn't properly represent them in a wrongful discharge case. And they brought the case in tribal court. And I went in and I said, sorry, there's exclusive jurisdiction somewhere else. It's not an affront to your sovereignty. It's just the subject matter isn't appropriate. But I needed to make sure and let the tribal court have the first assessment of whether or not they had jurisdiction. So I think that's important to know. There is that layer that needs to happen before, you proceed to your substantive issues in a civil jurisdiction matter. I know I glossed over that in a huge way. And before we talk more broadly about Montana tribal courts and the status of Montana tribal courts today, I wonder if you have any civil jurisdiction questions.
Jenna, one question. You talked about the EPA having jurisdiction on Indian land, specifically in your combusting ducks example. That is so
Yeah.
sad. I can't even
I
imagine.
know.
Um, do the tribes have any ability to establish their own environmental standards or, I guess, make that their own, or do they always have to file under EPA jurisdiction?
It's an excellent question, and I'm glad you asked it because, again, a case coming out of Montana in the early 90s, the EPA decided, you know what, we're going to treat tribes as states. It's called TAS status. And we're going to allow tribes that feel like they're up for the task of regulating um, Clean Water Act, Clean Air Act. We're going to delegate our authority as feds to the tribes. And CSKT was one of the first tribes to apply for Clean Water Act status. And of course, they were sued by the state of Montana and some municipalities on the reservation. And in that matter, they didn't apply the Montana test like we discussed, but they argued it as a pure delegation case. So the feds have the requisite authority to delegate that to the tribes. And so a lot of tribes, including Northern Cheyenne and some others, have taken on the function of regulating clean water, clean air, and I'm not sure what other EPA clean acts also have the delegated authority at this point. I kind of lost track, but definitely tribes, and some tribes have a lot of employees with ologists at the end of their um, I guess, names. And so some tribes have really built a lot of capacity to have the ability to do a good job of regulating water quality in particular. And I say that because water doesn't know boundaries. It doesn't care. So in the instance of Clean Water Act regulation, if the tribes have built that capacity, they do have the ability to proceed with um, the regulation of it.
Thank you. Yeah, I
Mhm.
was wondering about that. Does the EPA still oversee it?
There's a relationship there. Um, and I certainly can provide additional information on this, but um, I think that they have to have at least the same standards. And so I think there's a lot of collaboration and cooperation relative to the development of those standards.
Great, thank you. Another question here. Do tribal courts utilize juries in civil cases?
They can and do. I think it's up to the parties to determine if they want a judge trial or a jury trial, much like in state court. One of the first tribal court jury trials I've ever watched was a wasted meat case. And I believe that was a civil case, and that had a jury trial. I had a jury trial in Blackfeet and at Rocky Boys on civil cases, and they seated a jury. And we proceeded very much like a state court proceeding with, certainly with twists and nuances appropriate for that community.
Great. That's all we have for now. Thanks.
Great. Okay. And so I just wanted to I guess, conclude this with talking about the Montana tribal courts and kind of the state of the Montana tribal courts at this juncture. We talked about how Fort Peck went ahead and proceeded to be a pilot tribe to do the expanded jurisdiction in the criminal arena. We do have tribal courts that have been existing quite a long time. And I want to compare that to when I first went to DC for my first tour. I was an attorney with the National Indian Gaming Commission. And at that time, it was like the year 2000, the Indian gaming was becoming a big deal in California. And in California, you have rancherias and smaller tribes. And those tribes did not have, many of them did not have developed tribal courts. So they were quickly coming up with dispute mechanisms to deal with a lot of matters that disputes that were going to happen with the influx of people coming to gamble, influx of so many more employees that were going to come online. And so it started out with they would agree to arbitration and would define, a dispute resolution in those kinds of contexts. But there was, all of a sudden they had to kind of start from scratch to come up with judicial systems. Whereas in Montana, and, we've had active tribal courts for a good long time. And of course, I don't want to discount the traditional methods of dispute resolution as anything as in any way as invalid. So there's always been in time immemorial dispute mechanisms on reservations. But when I talk about tribal courts, I'm talking about it in the context of what non-Indians would recognize as more of a court system. What I think is really important to point out is the Montana tribal courts, even though they are limited relative to their authority in certain contexts, they are doing so much volume of cases. They're doing traffic, they're doing the criminal stuff like we talked about. They do family law, they do credit debit, debtor work. That's a typo, sorry about that. They're doing HR work, they're doing contract work. The last case I brought in tribal court was a contract dispute, breach of contract. It was a very large number, the case was. And the tribal judge, the chief tribal judge, who was a non-Indian, I mean, I'm sorry, a non-lawyer, managed that case just fine. And we ultimately got resolution in the case, but it definitely was a very big case that, had a number on it that would meet the federal standard. But it was happening in tribal court. Personal injury cases, probate. Probate gets complicated depending on the status of the land, but certainly typical tribal court docket is incredibly varied, and the tribal courts are working with a very large volume of matters. So I think from my perspective, we always have to keep in mind that it's not just like a JP court necessarily. They're dealing with big matters and very important matters, and a lot of our tribal courts are trying really hard to work on more of a holistic approach to some of the issues so that we're getting at the underlying causes of disputes. And so it's a very dynamic area of justice systems. And I think it's really fascinating stuff. I Some of the tribal judges are elected, some are appointed. Like I said previously, some of the usual practitioners are attorneys. They all have codes that have different provisions out there regarding who can practice in the tribal court and who can't. Fort, not Fort Belknap, the Northern Cheyenne Tribe has made huge efforts to provide training for advocates within their tribal colleges so that there's folks that are very specifically trained to be able to deal in those justice systems. So and some of them have bar examinations. I took a bar exam up at Blackfeet. It was a full day exam, and it was based on questions on their code. I know that Fort Peck has a bar exam as well. I have not taken that one. And some, like CSKT, you have to be an attorney in good standing of the State Bar of Montana, and you pay like $50, I think it is. But some of them said, uh, attorney of good standing in any other jurisdiction. So they all have different standards for who can practice, who can be a judge. They all have appellate courts, and they also have rules regarding that. Some of the tribal courts have very advanced rules of professional conduct, and it's all part of the demonstration that they are a separate bar and they will do what they need to do to make sure that when we're talking about dispensing judgment within their jurisdiction, they have infrastructure to be able to make sure that that goes well. So, lots of work to do for sure, but a lot of good stuff has happened and will continue to happen. And like I said, I'm very excited to see what Little Shell's going to do with a justice system. I am going to leave it there and open it up for any other questions you might have at this time.
Dana, one big question is, where do you see the direction now with tribal law and the cases that you've seen come out as far as will there be more responsibility given to the tribes or taken away from the tribes? What are you seeing that direction right now?
In the 70s, in 1973, the Indian Self-Determination Act was passed, and we continue to call this era the era of self-determination. And even this administration is very much oriented towards enabling tribes to manage their own affairs. And so I do think the trend is to try to um, establish tribal governments and tribal systems as entities that have the capacity to manage their own affairs. And like you saw the trend in the criminal jurisdiction component of my talk, the Congress has been more interested in giving more functions back to the tribes. Um, in a, I guess, broader sense, when you look at some of the movements that have happened relative to um, tribal co-stewardship, I think that that also is an indicator that the federal government sees tribes as a partner in land stewardship in some of those capacities and is interested in partnering with tribes who may have specific capacities in different instances or specialized knowledge to be able to manage and do some, I guess, in a sense, shared jurisdiction of public lands. So that's another, I guess, area to watch relative to that. It's it's hard for me to talk about building capacity because I don't mean to step on the good work that's already been accomplished. I don't want to say, oh man, we've just got so much work to do. We do, but at the same time, there's just been a lot of interesting efforts and collaborations. And I think that there's good proof out there that tribes are in a good position to be able to manage the affairs of their lands.
Yeah, definitely. It's always an evolution, right? So there's always going to be that change. So it's good to hear that from your perspective, that trend is going to what I think you would interpret as positive. Are there any resources that you would point the participants here to if they're interested in more information on these types of issues?
Boy, there's
Simple
this,
resources that they could check out at the
yeah,
library.
I'll say one of my favorite, I don't know what they call it anymore, blogs, if you will. I think maybe that's an outdated term, is called Turtle Talk. And it's you can get on their email list and they will send you all the updated cases and they have great archives related to all of these issues. And what is important to look at from my perspective is what's going on in the Eighth Circuit, the Tenth Circuit, what's happening in other circuits to see where, where we might have issues going up to the US Supreme Court that might, redefine or define some of these matters for us. So Turtle Talk is a really great resource. There's a whole lot of good books out there. Of course, the Bible is the Cohen Handbook on Indian Law. It is religiously updated and it's pretty gritty, but it's very good. And then I just think, the Department of Interior actually has some really great information on there. Website regarding who's an Indian and how do you find that out and who are the federally recognized tribes and just some of the basic information. The organization National Congress of American Indians has really good basic information about a lot of this and a lot of the pending legislation that might be affecting tribes. Given the nature of the federal Indian relationship, tribes aren't treated just like a special interest group, right? It's a political designation. So there's a very precise and um, immediate effort to ensure there's government to government reactions, and organizations such as the National Congress of American Indians does track trends or legislation that has been introduced related to some of these issues. I also think the Native American Rights Fund has a really good website. They actually do a lot of litigation on some of the larger, I would say more pan-Indian matters. They do represent individual tribes as well. They've got a great website, and they break it down for you, and also can give you information about where certain litigation is and what is they provide a lot of nice commentary in addition to just the materials themselves. That's what I like about Turtle Talk. They will link to the actual documents so you can just read it for yourself if you don't want the interpretation. But Turtle Talk also will post all the new scholarship related to the dynamic area of Indian law.
Hey, thank you so much. I really appreciate that. And I think that it's always good to point us in a direction of learning more. Um, Dana, we have a couple comments here, specifically thanking you very much that the talk was very informative. I would agree wholeheartedly.
Thank you.
I did learn so much, and I really appreciate your spending your evening with us. And to all the others on this call or this session of Citizens Law School, thank you so much for being here. We will have another session next Wednesday at this same time. Anna, if you're still there, would you remind me what next Wednesday is so I can tell the audience? I'm trying to figure that out for you all. I apologize. But next Wednesday, we will have another session, and I do appreciate all of the time that you've spent with us this evening. I hope everyone here has learned something new. If you are interested in knowing what that session is, there are Citizen Law School flyers out there, and you are welcome to contact us at that Zoom link or the information link to get more information as to what that next session is. I truly apologize for not being prepared with that. Outside of that, everyone have a really good evening. keep warm. It sounds like it's going to get cold out there, and be good to yourselves. Thank you so much.
Thank you.